Okay, welcome to the September 11th Planning Commission meeting for 2018. Madam Secretary, please call roll.
Ms. Casaubon? Here. Mr. Lauren?
Here.
Mr. Richardson?
Here.
Mr. Richard?
Here.
Mr. Willie?
Here.
Mr. Davis?
Here.
Mr. Manella? Mr. Fitzmaurice?
Here.
Mr. Doherty?
Here.
Mr. Drum?
Here.
Mr. Randolph?
Here.
Chairman, we have a quorum.
Thank you. Under public announcements, please silence all phones and pages. If you'd like to appeal the suggestion by the commission to the council, there's cards available up front. And if you'd like to talk for each one of these cases tonight, there's also speaker cards. The public will be able to speak 10 minutes for each side, 4 or 5, and 5 minutes for rebuttal. After we're finished with speaking about the case, you can please exit the building so we don't have to hear the noise come out from the back. The invocation will be done by Commissioner Randolph, and the Pledge of Allegiance will be done by Commissioner Richardson. Please stand.
Heavenly Father, once again, we come to you to say thank you for all the blessings you bestowed in our lives. We thank you for allowing us to experience this day. Lord, we thank you for allowing us to remember this day being a special day of 9/11, what transpired in New York. We ask that you continue to bless the families and the military personnel, law enforcement officers, firefighters, and medical personnel that lost their lives during that time, and the families as well. Heavenly Father, we thank you also for these commissioners. We thank you for the government that we serve, and Lord, we thank you for our citizens that we represent. And all these blessings we ask in your holy name. Amen.
All right.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd like to ask the commission for approval of the August 14 minutes. They had a chance to read it. Commissioner Randolph.
Motion to approve.
Motion to approve by Commissioner Randolph. Commissioner Lauren. I have a second by Commissioner Lauren. Any other communication on this matter? If not, please vote. It's very complicated minutes.
Okay, all right.
Please vote.
Motion carries.
Thank you.
Just go to the next slide.
Staff, are there any cases tonight that need to be postponed or withdrawn?
Yes, there are. We have two preliminaries. The Preserve at Goodby Lakes has requested postponement. Providence Park has requested postponement. Is it on now? Now? Okay. Two preliminary subdivision reviews have requested postponement. The Preserve at Goodby Lakes, 2018-1053-PP, and Providence Parks, 2018-1105-PP. And one final subdivision review, Southern Oaks Phase 1, 2018-1197-FP.
Thank you. To make it simple tonight, somebody on the commission would like to make a motion to approve the postponement or motion to vote on the postponement of these cases? Let me read the case first. 2018-1053 postponed, that's the Preserve at Goodby Lakes, Ward 1, District 3, developer owner D.R. Horton, Inc., Gulf Coast, engineer is Quality Engineering and Surveying, Parish Council District Representative, the Honorable James Thompson. Is there somebody here to represent that would like to explain why the postponement?
Yes, sir. Good evening. Jeff Shane of the Jones Fussell Law Firm, P.O. Box 1810 in Covington. Which button, green? Either? Yeah, I hear feedback now. It's good to practice an intro anyway.
Sure.
Good evening. Jeff Shane of the Jones Fussell Law Firm, P.O. Box 1810 in Covington. I represent the owner or the developer of the Preserve at Goodby Lakes that has been postponed by this honorable commission for the last few months. We request postponement this evening as we have struggled with fill issues as it relates to staff commentary. We have gone to the administration to assist in the discussions, and we understand that the administration was to conduct a meeting last week, maybe Tuesday or Wednesday, but certainly one of the storm days where parish government was closed, and they were unable to have that meeting. We have not gotten any feedback as a result of the inquiry we've made. So we're not trying to unduly delay the processing of the case, but there has been to this point no one from the general public that has come to the meetings to give input or to, I guess, ask why this matter continues to be postponed. And we want to try to get it right, and that's why we're trying to have continued discussions with regard to this delicate issue. Mr. Marone, my law partner, is handling the next case, and I realize you will consider these individually, but we both decided that rather than him come behind me and parrot everything I've just said, his case is literally in the same geographic area, has the same exact issue, and he too awaits further discussion with the administration as it relates to the fill issue. I say that so that if you have questions about either case, I know you won't be bashful to ask us, but maybe we can make it at least a little more efficient as it relates to why we request postponement. We do hope to be back before you in October to present these cases. That is our intent.
Thank you.
Mr. Chair.
Is there anybody in the public that has opposition to the postponement? If not, I'll bring it back to the commission. Commissioner Doherty.
Thank you, Mr. Chairman. I will put a motion on the floor to postpone 2018-1053 PP. Now, you haven't read 1105 into the record yet. Do you want me to go ahead and put that as part of the motion?
No, I'll go ahead and read that next.
Okay.
Commissioner Fitzmaurice.
Second.
I have a motion to postpone by Commissioner Doherty and a second by Commissioner Fitzmaurice. Please vote.
Motion carries.
Thank you. Case number 2018-1105 PP, Providence Parks Phase 1, Ward 1, District 3, developer owner, Providence Parks LLC, engineer SLD Engineering and Surveying, Parish Council District Representative, the Honorable James Thompson. Discussion was already heard on this matter. Commissioner Randolph.
Motion to postpone.
Commissioner Fitzmaurice.
Second.
I have a motion to postpone by Commissioner Randolph and a second by Commissioner Fitzmaurice. Please vote.
Motion carries.
The third postponement request is 2018-1197 FP, Southern Oaks, Phase 1, Ward 1, District 4, developer owner, Yannon LLC, engineer is Kyle Associate LLC, The Parish Council District Representative is the Honorable Michael Lorino. Yes.
Thank you, Mr. Vice Chair. Paul Marone on behalf of Yannon LLC. We would request tabling of the final approval of this phase of Southern Oaks. There are a number of significant items that are still not completed. We need the additional time to get those to completion so that we can come before you hopefully in October with a clean punch list for your consideration at that time. Thank you.
Is there anybody in the audience for opposition on this postponement? If not, I'll bring it back to the commission. Commissioner Casabon,
I'll make a motion to approve, to the postponement.
postponement. Commissioner Fitzmaurice.
I'll second. And just a comment, I assume that all three postponements are 30 days?
That is correct. All three postponements tonight are 30 days.
Second.
I have a motion by Commissioner Casabon to postpone with a second by Commissioner Fitzmaurice. Please vote.
Motion carries.
The Vice Chair has received a request to move up old business, one of the old business accounts. It's the Money Hill Act of Correction. Developer owner Sally Goodyear, surveyor Edward Murphy, Parish Council District Representative the Honorable Richard Tanner. Of course, I'll need a motion to vote on this matter. Is there anybody? Commissioner Fitzmaurice.
I'll make a motion to move it up on the agenda.
Commissioner Fitzmaurice makes a motion to move up. Commissioner Willie? I got a
Second.
second by Commissioner Willie. Please vote.
Mr. Richardson? Thank you. Fitzmaurice, did you vote? Hold on, this thing's all sort of broken. All right, try it again.
Thank you.
Ms. Casabon? Yes. Can you vote again, please? We voted. Motion carries.
Thank you. Staff,
Yes, this is an act of correction for lots 25, 73, and 74 in Money Hill Plantation, Phase 1. Honorable Commissioners, the above caption, act of correction has been reviewed by the Department of Development Engineering and no objections offered. Therefore, it's recommended the act of correction be approved.
okay. Is the petitioner here for that, or? what? Yes, ma'am.
When the drainage easements were laid out.
I'm sorry, would you state your name and?
When the drainage easements were laid out, Krebs LaSalle did it, and this particular drainage easement came from across the street, under the street in a culvert, and then up the hill. Well, obviously, it's not going to go up the hill. It comes between the two lots. So the lot on one side has been developed, the lot on the other side is not developed, but we would like to have a drainage easement. I think we're both in agreement. We would like to have the drainage easement go between the two lots where it was supposed to go. We met with Shelby LaSalle, and he suggested we just come here and do an act of correction.
Thank you.
Thank you.
Is there anyone in the public against this position? If not, I'll bring it back to the commission. Commissioner Fitzmaurice.
I'll make a motion to approve.
Motion to approve by Commissioner Fitzmaurice. Commissioner Richard. Second by Commissioner Richard. Any more discussion? If not, please vote.
Motion carries.
Thank you. Okay, get back to entering parish rights of way, servitudes, easements, and entering the Tammany trace, none. Minor subdivisions. Case 2018-1168 MSP, a minor sub of panel A, 12.3 acres into parcels A1, 6 acres, parcel B1, 6.29 acres, W10, D6. Owner is Thomas and Deidre Faraday. Surveyor is John C. Cummings and Associate. Parish Council District Representative, the Honorable Richard Tanner. Staff comments?
The reason for the public hearing is that the parcels have already been a part of a previously approved minor subdivision. The following revisions will need to be made to the submitted survey. One is to include the planning commission chairman's signature line, revise parcels to read A1 and A2, and reference the previous minor subdivision dated December 1996. Staff recommends approval of the request upon the revisions being complete. The minor subdivision adheres to all minor subdivision requirements.
Is the petitioner here? Yes, sir.
Yes, Tom Faraday, I'm the owner of the property. Yeah, I just wanted to subdivide it. It's already got 2 dwellings on it. Before we bought the property, it was approved to, we were told the footage we would need and all that, so my plans all along were to subdivide it and sell part of it to my son, so
Fine.
that's all we're looking for is to get that approval.
Thank you.
Thank you.
Is there any opposition to this case? If not, I'll bring it back to the commission. Commissioner Lauren.
Sir, could you come up for just one
Mr.
moment?
Farad.
For the record, do you agree with these 3 requirements?
From what I understand, it's just on the survey, making it A1 and.
They're pretty simple, but just for the record.
It's survey requirements, and I'll usually contact the property owner and the surveyor and let them know what changes need to be made.
Okay,
It doesn't really change the survey or the size or anything, does it? I didn't think so.
okay, thank you.
Thank you.
Do you have a motion?
In that case, I make a motion to approve.
A motion to approve by Commissioner Lauren. Commissioner Casabon.
I'll second that motion.
I have a second by Commissioner Casabon. Any more discussion? If not, please vote.
Motion carries.
Case number 2018-1193 MSP, a minor subdivision of lot LL1 into lots LL1A, 1.26 acres, LL1B, 1.26 acres, W1D3. Owner is C&C Home Builders LLC. Surveyor is Edward J. Murphy, PLS. Parish Council District Representative Honorable James Thompson. Staff, any comments?
The reason for the public hearing is that the parcels are part of a previously approved minor subdivision. Staff recommends approval as the minor subdivision adheres to all minor subdivision requirements.
Is the petitioner here for this case? Please come up, sir, and state your name for the record.
My name is Carl Cadis. I'm with C&C Home Builders. And we bought the property, and it's, I think, meets all the requirements. We just want to divide it in half.
Okay.
And that's it, sir.
All right, thank you.
You are.
Is there any opposition to this case? If not, I'll return it back to the commission. Commissioner Casabon.
So staff has no problems with this. It meets all our requirements. I'll make a motion to approve.
Motion to approve by Commissioner Casabon. Commissioner Randolph.
Second.
Second by Commissioner Randolph. Any more discussion? If not, please vote.
Motion carries.
Thank you. Another minor subdivision. 2018-1198 MSP, a minor sub of a 61-acre parcel into parcels A, B, C, D, and E, W5D6. Owner is the estate of Della L. Dillard. Surveyor is John C. Cummings and Associate. Parish Council District Representative Honorable Richard Tanner. Staff?
The reason for the public hearing is that 2 parcels do not have parish road frontage and more than 1 parcel is accessed by a private drive. Staff recommends approval of the request upon the below revisions being completed. There needs to be a planning commission chairman signature line, remove parcel B3 and delineate it as a 40-foot parish right-of-way plus the private drive. Include all of Nickens Road as parish maintained. The owner is proposing to create 5 parcels from a 1-parent parcel. However, parcels C and E do not meet the minimum lot frontage requirement of 150 feet for A2 suburban zoning district. A waiver of the regulation is required by the commission. More than one of the parcels are accessed by a private drive. The drive must be constructed to a minimum parish standard in accordance to section 125, 189 minimum construction standards for a private drive. If approval is granted, the applicant must then coordinate with the Department of Development and Engineering by providing plans for construction of the private drive.
Is the petitioner here? Yes, ma'am.
I am Diane Dillard. I am the daughter of Della Dillard. And all we're doing is dividing the property by her will.
Okay, thank you. Is there any opposition to this case? If not, I'll bring it back to the commission. Commissioner Darty.
Thank you, Mr. Chair. Question to either staff or the owner. On parcel A, there's a little triangular section that says not a part of A. What is it a part of?
It was deeded to my nephew about 6 years ago. It's already his.
Okay. And Nickens Road looks like it runs into Dillard Road. Where does Dillard Road actually go to a major thoroughfare?
It comes in off of Highway 21.
Okay.
Comes through 6/10 of a mile to my house and then on past to the other houses.
Okay.
On through
Well, it
there.
just didn't show, and
Yes.
now Nickens Road, it comes on down, looks like to the back part of parcel D, and then there's a 40-foot right-of-way.
The right-of-way is over on our property. It's a private road that my brother and his son built.
Okay.
That 40-foot right-of-way there.
So in order to get to parcel C and E, they're gonna use Nickens Road to the existing 40-foot right-of-way?
Correct.
Okay.
It makes a silly little S right there. Yes, sir.
All right. Thank you.
You're welcome.
Commissioner Casbon.
I'll make a motion to approve, subject to all the staff comments. If you agree to what the staff is asking you to do. So I'll make a motion to approve.
Motion to approve by
We
Commissioner.
need the waiver?
Yes.
It's a waiver for the right
Is that
of way.
with the waiver?
With the waiver, yes.
With the waiver?
Yes, sir.
Commissioner Randolph.
Question I thought Mr. Doherty was going to address. There's another, Miss Della? Miss Dillon. On parcel, it's right below parcel D. There's a square box that says not a part. What is that?
Oh, in the middle, there's 15 acres that was sold out years ago.
Okay. It's right next to parcel B. There's a,
Oh, that is Sissy Nickens. Her and her husband owned that 15 acres. Their son-in-law and daughter own 14 of it, and I think Sissy just has that 1 acre there. But that's not part of the land that we're fooling with.
okay. Okay.
It was part of the original plaque, but now it's not. It hadn't been for 40 years.
Okay. All right. I move the second.
I have a second by Commissioner Randolph. Before we vote on this, I believe legal would like to make a comment.
Only a request for clarification from staff. There's a reference to a parish-maintained right-of-way in your comments to be identified as B3, and I thought I understood that, but it sounds a little inconsistent with comments that Ms. Dillard made concerning a driveway.
So after I talked to Joey in Public Works, Dillard Road comes in and goes all the way to where it says not a part, where that square is, where it says Nickens not a part, and there's another not a part. So what we were saying is it doesn't need to be named as its own parcel because it's an existing parish road.
So Dillard Road runs east-west and then turns south
Yes,
between parcel A and parcel D?
yes.
and continues all the way down to the point where it, I guess, ends, providing access to parcel C and parcel E?
It doesn't run quite that far down, so that's why there's also a requirement that they have to provide the private road access.
Okay, so it stops at the midway point, let's say, at the, next to the Nickens property? Okay,
But there is an existing road there,
okay.
so
And Ms. Dillard, you understand that that's a parish-maintained road up to that point?
Yes.
Okay.
The Dillard Road section is the section on the side there, the 40-foot right-of-way right there is not parish-maintained.
Is that
It's private.
consistent with
There-
staff's understanding?
there's two roads that run very closely
parallel.
together.
Okay.
So it is something that I'm gonna have to get with John Cummings with to clarify and make
Clarify.
sure that we're not overlapping the parish maintained and the private drive. Yeah.
And that it's consistent with Ms. Dillard's understanding of what is private property and what
Correct.
is, for lack of a better word, parish property?
Yes,
Yes.
there's a fence between them two.
Okay, thank you, ma'am.
Thank you for that legal description. Okay, we have a motion by Commissioner Casabon to approve with the waiver, and a second by Commissioner Randolph with the waiver. Any other further questions? If not, please vote.
Motion carries.
Thank you. Okay, under petitions or request, Dove Park subdivision, Square One, Lot 16, W4D5, Surveyor H.C. Sanders and Associates, Inc., Parish Council District Representative, the Honorable Riker Toledano. Staff, your comments?
The reason for the public hearing is per section 12584 contiguous lot rule. Lots within Dove Park subdivision are required to have a minimum lot frontage of 70 feet. The planning commission is responsible for reviewing the request for buildings on a buildable substandard lot of record. In order for the planning commission to approve the request, the petitioner must provide proof that they do not currently own or has not sold, nor has any predecessor in deed or title sold any contiguous lots during the period following the initial adoption of the rule ordinance in January 20th, 1994. The petitioner is requesting to build on a 50 by 205-foot lot within Dove Park subdivision. Staff does not have any objection to the request, as the petitioner has the opportunity to purchase lot 16 without the option to acquire any adjacent property.
Is the petitioner here for this case? No? Okay. Is there any opposition to this case? If not, I'll bring to the commission, Commissioner Darty.
Thank you, sir. Since no one's here to represent the petitioner, I'd move to postpone until our next meeting.
I have a motion to postpone by Commissioner Darty. Commissioner Drum.
I second.
I have a second by Commissioner Drum. Any more comments? If not, please vote.
Motion carries.
Thank you very much. Under preliminary subdivision review, we postponed the first two cases. We'll go to case 2018-1148 PP, River Club Phase 2, Ward 1, District 1, developer owner, River Club Development LLC. The engineer is Kelly McHugh and Associates. The Parish Council District Representative is the Honorable Marty Dean. Staff?
This project was postponed at the August 14, 2018 meeting. Preliminary plans and hydrologic study have been reviewed by this office and inspection of the site was made. It's recommended that the preliminary submittal be approved subject to the following comments. General comment number 1, the developer requested a waiver of regulations for the minimum finished floor elevation for lots along the waterway to be 12 inches above the street. Number 2, the developer requested a waiver of regulations for the maximum block length of 1,500 feet. Number 3, the developer requested a waiver of regulations for the detention requirements in accordance with Ordinance 11-2426. Therefore, the Department of Development has calculated the drainage fee in lieu of detention as follows: 38.15 acres for $2,000 an acre for $77,020. This calculation includes the entire footprint of Phase 2. However, in 2013, the Planning Commission approved the developer's request in River Club Phase 1 to exclude the green space and waterways from the calculations. Similarly, the developer has requested or has submitted a letter, see attached, detailing the request to remove the green space and waterways from the area used for the calculation in the fee in lieu of detention for River Club Phase 2. If the Planning Commission agrees with the request, the following calculation can be used: 27.55 acres at $2,000 an acre for $55,100. Please note that unlike Phase 1, the developer is proposing to install a walking path in the Phase 2 green space. The fee should be due prior to the issuance of any work orders by the parish. Number 4, provide the geotechnical report that's referenced in the typical street section for the preliminary plat. On the preliminary plat, number 5, include in the restrictive covenants that the HOA will be required to maintain the proposed walking trail. On the paving and drainage plan, number 6, subsurface pipe which encroaches onto lot 136 needs to be relocated to within the road right-of-way. Number 7, relabel section CC detail as simply a walking path detail or provide a location for the section on the plan sheet. The sewer and water plan, number 8, show the access drive for the lift station and the lift station detail on the paving and drainage sheet. Number 9, plans and specifications for the construction of the project's water distribution lines and sewer collection lines have not yet been approved by LDH. SWIP and signage plan. Number 10, the coastal use permit on file for River Club expired in 2017. Provide this office with a current coastal use permit. Informational items, no funded maintenance obligation is required since this is an extension of a private subdivision. Mandatory developmental fees will be required at final submittal in accordance with St.Tammany Parish Code of Ordinances, Part 2, Land Development Code, Chapter 125, Subdivision Regulations, since no public hearing was held prior to January 1st, 2005. The developer is hereby advised that upon application for final subdivision approval, the engineer of record for this development shall certify in writing that all aspects of construction have been completed in accordance with the approved plans and parish ordinances. If any construction activity is proposed that's not in substantial compliance with the approved plans and parish ordinances, the engineer of record for the development shall notify in writing the Department of Development prior to beginning said construction activity. The developer and/or engineer of record shall obtain written approval from the Department of Development prior to beginning any proposed construction activity that is not in substantial compliance with the approved plans and parish ordinances. Revised drawings will not be accepted prior to the September 11, 2018 Planning Commission meeting to ensure that any additional comments at the meeting can be incorporated into the revised plans.
Thank you.
Thank you, Mr. Davis. Members of the commission, Paul Marone on behalf of River Club Development, LLC. The case before you now is for Phase 2. The next case on the agenda is for Phase 3 of the same. The staff comments are largely the same, so my comments with regards to Phase 2 would also be the same comments for Phase 3. In regards to the staff's comments regarding the various changes to the plat, we have no objection and will make all of the changes as requested. The primary items in the comments that I'd like to address are the 3 waivers and the coastal use permit. You may recall last month I went through each of these waiver requests, but at that time you did not have the plat in front of you and have an opportunity to review that. So I'll just touch on each of these briefly again, since I know that I touched on them last week and you have some familiarity with them. But with regard to the first waiver, that the finished floor elevation for the lots along the waterway be 12 inches above the street, waiver of that regulation. As you'll see from the plat, there is a significant fall from the street down to the bayou on many of these lots. So to have the finished floor elevation above the street would create a significant elevation change from how you would otherwise typically build in this area. So we would request a waiver of that regulation, noting that, of course, the finished floor elevation will still be well above the base flood elevation as required by FEMA. Secondly, the waiver of the block length limitation of 1,500 feet. Several points with regards to this item. First, the layout before you is consistent with the PUD plan that was approved as well as Phase 1. Secondly, the natural characteristics of the ground and the bayou in this area really don't dictate another feasible alternative than what we show before you. Finally, we are only requesting a waiver of about 165 feet, so it is not a significant variation from the rule. Finally, the third waiver is with regards to the detention requirements, and as staff noted, this particular waiver was granted for Phase 1. It has been granted on at least 3 other occasions on other subdivisions that I've been involved with. Bushwood Estates, which is actually under old business this evening on another issue, was one of those developments. And what we're requesting is that the calculation for the fee exclude the green space areas and the bayou, as those areas will be unaffected by the development and the construction activities. So we would respectfully request your approval with each of those waivers. In regards to the coastal use permit, Mr. Tom Brown is our consultant. He is working and has filed for the extension of that permit. We hope to have that shortly. Do not anticipate any problems with that, and we'll be happy to provide that to staff once it is received. With that said, we'd respectfully request your approval of preliminary for Phase 2 of River Club development. And as I mentioned prior, these comments would also hold true for the next case, which is Phase 3 of River Club. Thank you.
Thank you. Is there any opposition to this case? I'll bring it back to the commission. Commissioner Lauren.
Yes. I drove out there this afternoon, and if you were to try to design this subdivision or design any subdivision on this particular tract of land in any other configuration, I don't think it would work. So the waiver for that, I don't have any problem with, nor the others. And with that said, I'd like to make a motion to approve.
I have a motion to approve with all 3 waivers by Commissioner Lauren. Commissioner Richard.
Thank you, Mr. Chair. I also agree with those comments and will second it. I do want to make another comment that maybe perhaps not related to this, but in the general comment 3, the waiver we're asking on the calculation, which you have recommended and I have seconded. This is an issue that we probably need some further clarification from the council on, and maybe getting the ordinance clarified, because we have precedent, it makes sense, we seem to waive this in every case, and if that's the case, then it probably ought to be addressed by the council. That's my comment there. Thank you. Legal would like to talk.
And Mr. Richard, in response to your comments, you're correct. There has been in some cases a precedent set for adjusting the calculations when certain conditions apply. And particularly, as I appreciated, that relates to when certain portions of the development remain in a pre-development as defined in the code as heavily forested state. Well, of course, waterways, you have to take that, a little differently, but basically untouched, as Mr. Marone said, unaffected by development activities. Of course, in this particular phase, since the question is raised, the walking path is referenced by staff. To what extent the walking path is not an effect on development activities, I'd be interested in knowing from Mr. Marone. It may be planned to be designed and constructed in a way which is more of a natural as opposed to what, at least in my mind, is a walking path.
Thank you. Yes, if you look at the detail with regards to the walking path on the plans, you'll see that it's a natural walking path at grade. So it's not paved, it's not aggregate, it is pervious, it is not impervious surfaces coming into the area, so it will remain natural.
I think it should be noted by the commission that I think that's a little bit inconsistent with what you guys have approved in the past. However, it sounds like what he has described is minimal impact.
I have a motion to approve by Commissioner Lauren with the three variances, the waivers, is that correct? And a second by Commissioner Richard. Oh, Commissioner Drum, sorry. Commissioner Drum.
Okay, Paul, how's that? This natural walking trail, who maintains it?
The homeowners association will be charged with maintaining it,
So it can actually grow back to its natural state then?
if not mowed, yes.
Okay. And one more question. This proposed waterway, is that going to be dug out to be the same depth as the existing bayou?
Yes, yes, it will connect to and be consistent with the existing bayou that's there.
Okay, thank you.
Yes.
Let me repeat. Any further comments? If not, we have a motion by Commissioner Lauren to approve with the waivers and a second by Commissioner Richard. Please vote.
Motion carries.
Thank you. The next case. I just missed that. River Club Phase 3, Ward 1, District 1, developer owner, River Club Development LLC, engineer Kelly McHugh and Associate. Parish Council District Representative is the Honorable Marty Dean. Staff?
Preliminary plans and hydrologic study have been reviewed by this office and an inspection of the site was made. It's recommended that the preliminary submittal be approved, subject to the following comments. General comment number 1, the developer requested a waiver of regulations for the minimum finished floor elevation for the lots along the waterway to be 12 inches above the street. Number 2, the developers requested a waiver of regulations for the maximum cul-de-sac length of 700 feet to 875 feet. 3, the developer requested a waiver of regulations for the detention requirements in accordance with Ordinance 11-2426. Therefore, the Department of Development's calculated a drainage fee in lieu of detention as follows: 31.05 acres for $2,000 an acre for $62,100. This calculation includes the entire footprint of Phase 3. However, in 2013, the Planning Commission approved the developer's request for River Club Phase 1 to exclude the green space and waterways from the calculation. Similarly, the developers submitted a letter, see attached, detailing the request to remove the green space and waterways from the area used for the calculation for the fee in lieu of detention for River Club Phase 3. If the Planning Commission agrees with this request, the following calculation can be used: 15.34 acres times $2,000 per acre for $30,680. The fee shall be due prior to the issuance of any work orders by the parish. Number 4, provide the geotechnical report that's referenced in the typical street section on the preliminary plat. Sewer and water. Number 5, plans and specifications for the construction of the project's water distribution lines and sewer collection lines have not yet been approved by LDH. The SWIP and signage plan. Number 6, coastal use permit on file for River Club expired in 2017. Provide this office with a current coastal use permit. Informational items. No funded maintenance obligations required since this is an extension of a private subdivision. Mandatory developmental fees will be required at final submittal in accordance with St. Tammany Parish Code of Ordinances, Part 2, Land Development Code, Chapter 125, Subdivision Regulations, since no public hearing was held prior to January 1st, 2005. The developer is hereby advised that upon application for final subdivision approval, the engineer of record for the development shall certify in writing that all aspects of construction have been completed in accordance with the approved plans and parish ordinances. If any construction activity is proposed that is not in substantial compliance with the approved plans and parish ordinances, the engineer of record for the development shall notify in writing the Department of Development prior to said construction activity. The developer and/or engineer of record shall obtain written approval from the Department of Development prior to beginning any proposed construction activity that is not in substantial compliance with the approved plans and parish ordinances. Revised drawings will not be accepted prior to the September 11, 2018 Planning Commission meeting to ensure that any additional comments at the meeting can be incorporated into the revised plans.
Thank you, Jay, for that very quick and precise. explanation. Paul?
Thank you, Mr. Davis. Paul Marone again. As I mentioned in the last case, the comments here are largely the same. The only difference is rather than the waiver on the block length, it's the waiver on the cul-de-sac length. And there is no walking path in the green space in this particular phase. So we would respectfully request your approval with the 3 waivers, subject to the rest of the staff comments, and in line with my comments on the prior case. Thank you.
Thank you. Is there any opposition to this phase of the development? If not, I'll bring it back to the commission. Commissioner Lauren.
Well, Paul said ditto, and I'll say the same thing. This is just phase 2 of the same project, so, or another phase of the same project. So I make a motion to approve with the waivers.
Motion to approve with the waivers. Commissioner Richard.
I'll second.
Okay, second by Commissioner Richard. Any more discussion? If not, please vote.
Motion carries.
Okay, we go into our final subdivision reviews. Case 2018-1196 FP, Beatico Creek Parcel C1, Ward 1, District 1. Developer owner Beatico Creek Preserve LLC, engineers Kelly McHugh and Associates, and the Parish Council District Representative is the Honorable Marty Dean. Staff?
Periodic inspections have been made by this office during construction, and the final inspection was made on August 20, 2018. The inspection disclosed that all of the concrete roads are constructed, the road shoulders are constructed, and the roadside swales are functioning. The following uncompleted items existed at the time of final inspection and will be completed before the plats are signed. General comment, number 1, we need base test results. Number 2, 911 addresses need to be included on the plat. Number 3, need all traffic signage installed. Number 4, need an act of correction for parcel B to remove a portion of parcel B from lots 123, 171, and 807 within parcel C1. 5, need benchmark location and description shown on the plat. Number 6, the footprint of parcel C1 needs to be correctly shown on all drawings as shown on the plat. Number 7, we need a typical driveway swale cross-section shown on the plat and as-built paving and drainage plan. Number 8, show a revision date on all drawings that are revised. Number 9, provide a signed and completed fill and grading statement for the project. On the final plat, number 10, Scenic Drive needs to be revised to Myrtle Grove Court in order to avoid street name duplication issues for 911 addressing. Sewer and water plan, number 11, a negative bacteriological report relative to the construction of the project's water system has not been issued by LDH as required. 12, a letter of acceptance and responsibility for the perpetual maintenance and operation of the water and sewer system has not yet been issued by the utility provider as required. The SWIP and signage plan, number 13, add a no outlet sign to Scenic Drive and update the legend to include this information. 14, remove the construction entrance call-out from the as-built SWIP plan and signage plan. Informational items, should the Planning Commission approve the request for final approval, a warranty obligation will be required for the infrastructure in the amount of 750 linear feet at $25 per linear foot for $18,800 for a period of 2 years. Staff recommends approval of the proposed final subdivision request subject to the developer complying with all comments and no plats to be signed until all items are satisfactorily completed. No mandatory developmental fees are required since a public hearing was held prior to January 1st, 2005. The subdivision is within the urban growth boundary line, and revised drawings will not be accepted prior to the September 11, 2018 Planning Commission meeting to ensure that any additional comments established at the meeting can be incorporated into the revised plans.
Thank you. Paul?
Thank you, Mr. Davis. Paul Marone again, this time on behalf of Beatico Creek Preserve LLC. This project is a relatively minor phase in Beatico Creek subdivision, consisting of only 4 lots and 1 common parcel for the homeowners associations used with regards to storage, boats, and things of that nature. As Mr. Watson noted, all of the field work as far as construction activities are done. The only field work that is left is the installation of the signage. We had hoped that the permanent signs would be in so that they could be installed this week. They did not come in, and so our contractor's in the process of installing temporary signs, which will be in before the end of the week. So that is the last item that needs to be completed in the field, and it will be done so shortly. We received the base test results today and are prepared to submit those. We also received the executed fill and grading statement from the developer, and we are prepared to submit that. The negative bacteriological report, we understand from Tammany Utilities, has passed. We requested from Tammany Utilities today the letter of acceptance. We hoped to have that by the meeting this evening, but certainly we expect it to be forthcoming within the next day or so. To the best of our knowledge, there is no further work that is needed with regards to the sewer and water system, and we expect their acceptance. Other than that, the last item I would note, the act of correction. Obviously, we did not want to prepare and have executed the act of correction until we were certain that this phase would be approved as it is configured. Once that happens, we will prepare that. Mr. McHugh, our surveyor, will execute it. We will submit it to your staff for their review prior to recordation with the clerk of court. With that said, we would respectfully request approval for Phase C1 of Beatico Creek, and I'll be happy to answer any questions that any of the commissioners may have. Thank you.
Thank you, Paul. Is there any opposition to the final subdivision review? If not, I'll bring it back to the commission. Commissioner Fitzmaurice.
I make a motion to approve.
I have a motion to approve by Commissioner Fitzmaurice. Commissioner Drum.
Second.
I have a second by Commissioner Drum. Any more conversation? Nope. And this is subject to staff comments, correct? Yes. Okay. With that, let's vote.
Motion carries.
Next case, amendments to Chapter 125 subdivision regulations. An ordinance to amend St. Tammany Parish Code of Ordinances subdivision regulations sections 125 to 188 minor subdivision review relative to private drives in prior use in use prior to the establishment of growth boundary line. Staff?
This is an ordinance put together by Richard Tanner of Council District 6. Basically, this is allowing people that live above the urban growth boundary line to not have to go to public hearing if their parcels are already existing on a private drive. And that's the meat of it. That's it.
That's it? Okay. Do I have any opposition from the audience about this ordinance? If not, I'll bring it back to the commission. Commissioner Lauren.
I have a question. The urban growth line is, if you look at it on the map, east to west, it's coastal. It's right down on Lake Pontchartrain, fairly close.
It runs east and west, and it's north of I-12.
Yeah, but what I'm saying is it runs parallel to 12. And over time, as the parish grows, that line's gonna grow up. It's gonna have to be adjusted further north. And how is that gonna be taken into account where will the people be grandfathered in that are today north of the line, but 2 years from now will be south of the line?
Commissioner Lauren.
Pardon?
I think legal would like to speak on this matter, if you don't mind.
Okay.
I'll call you back on.
In an effort to help, Mr. Lauren, and your question is well noted, as I appreciate this ordinance, it as Ms. Kara had described, and further I'll describe, in that it addresses only the limited situations where rural parcels having driveways already in existence, predating November 2010, are subdivided. You know, they're large parcels, and then they want to subdivide them into smaller parcels, a lot of times for family reasons. Then they're allowed to remain with the driveway access to those new parcels, if you will, as opposed to having to meet the parish road driveway standards. So it's really an effort to acknowledge the special character of the rural areas, how right now they're large lots, and over time they are getting subdivided to parcel out to families, but they're still primarily used for families, and so the driveways that are already in existence are going to be accessing the new parcels, if you will. So they're not really going to have any impact in the terms of, you know, growth of the parish. Of course, that's different from situations where parcels are subdivided for the purpose of development and selling off of lots and having to build new driveways. We're only talking about parcels that already have existing driveways or private drives, whatever you want to call them. And and to allow that to continue without having to meet that special private drive standard, but only north of the growth boundary line.
Okay, but tonight we've had some subdivisions, re-subdivisions. We have them every month. If we have one next month that's not in existence now, and it's north of the line,
Then
are they gonna be exempt?
No.
No.
They will have to meet the parish
Okay,
private
that
drive
answers my
standards.
question.
It's only if they existed prior to November 10, prior to November of 2010, when the North Urban Growth
Okay.
Line was
That
first
answered-
established.
You've answered my question.
And for instance, tonight that we talked about the one on Dillard Road, most of that road is parish maintained. However, the last part of it is a private drive. So in that instance, they can utilize the rest of that private drive without having to come to a
Well, if you didn't
public
have,
hearing.
if you didn't have this cutoff date, I could see where it would be an administrative nightmare to try to keep track of this going forward. But you've answered my question. Thank you.
Well, that's right, and not to belabor the point, but the applicant would still have to provide some sort of proof that the road existed prior to November 2010. But with Google Earth and other technology, that's not such a hard thing to accomplish.
Okay, thank you.
Commissioner Lauren, would you like to make a motion, or?
Well, I'll make a motion to approve then.
Got a
That was the only
motion?
question I had when I read through it.
Commissioner Casabon. I have a second by Commissioner Casabon. Can you please vote?
Motion carries.
Under old business, Bushwoods Estates replat, SDO 30911F, developer owner Deborah Hogan, surveyor John C. Cummings, and associate parish council district representative, the Honorable Richard Tanner. Staff?
Mr. Paul Pomerone has requested that the Bushwood Estates go through the replat process, which y'all approved, I believe, in 2016, once before. In light of the Army Corps of Engineers no longer using a servitude, they are reconfiguring some lots. They're not adding any new lots to the plat, but they are reorganizing them.
Yes, Paul.
Thank you, Mr. Davis. Again, Paul Marone, this time on behalf of the Hogans, who are the developers of Bushwood Estates. Bushwood Estates was first approved back in 2005, and as you'll see from the plat in your package, all of the lots abut the Pearl River Navigational Canal. They front on the canal, and since the inception of the canal, the Army Corps of Engineers has maintained a maintenance servitude off of the canal. In some instances, as much as 100 feet, some, in other instances, even more than that. Well, back in 2005, there really was no mechanism to get approval from the Corps to be able to build permanent structures within that servitude area. So we were required to design the subdivision around the servitude so that each of the lots had a buildable area. As you may know, since then, the Corps has determined that it is no longer going to maintain the canal. There are discussions about whether that canal is going to be turned over to the state, kept under federal hands, whether the parish will have some say in it or not. At this point, we really don't know what the long-term use of the canal will be. However, what we do know is now the Corps, because of their position of no further maintenance, is entertaining and approving permits to be able to construct within the servitude area. It now brings the land which was otherwise unusable for structures into play. With that being the case, there is a better method to utilizing this ground. If that servitude had not been there in 2005, we would have laid these lots out quite differently. So what we are asking tonight is to replat the lot, to move these lot lines so that we can utilize the property as it would have been used if, in fact, that servitude hadn't been in place, or if they had had the mechanism in place to allow permitting for structures within the servitude. My client has already applied for and has received a permit for the construction of a permanent building within the servitude. We did that purposefully to make sure that we understood before we came to you and asked for the replat how that process would work, and to make sure that it was feasible and doable by us as well as any buyers. So with that said, we would ask that the replat be approved. As Ms. Bartholomew noted, we are not adding any additional lots, nor are any of the lots being reduced below the 1 acre requirement for the zoning of the property. It's just the movement of lot lines to better utilize the ground. So I would be happy to answer any questions that any of the commissioners might have, but we would respectfully request your approval of the replat for Bushwood Estates.
Thank you. Is there any opposition to this replat? If not, I'll bring it back to the commission. Commissioner Kesbon.
I'll make a motion to approve.
I have a motion to approve by Commissioner Kesbon. Commissioner Randolph?
Second.
I have a second by Commissioner Randolph. Commissioner Drum?
Paul, looking at this little drawing I have here, are they going to extend the property lines now into the servitude area?
The property lines have always extended into the servitude area. The servitude was always part of a lot.
Okay.
It's just that we had to carve out a buildable area within that lot outside of the servitude line. We now don't have that limitation. So, yes, all of the lots, or just about all of the lots, have some servitude on them, but now that is buildable with the permit from the Corps.
Okay, so the people they can plant their vineyards and all that in there now, right?
They've always been able to plant their vineyards. Now they can actually build their homes or boathouses in there.
Commissioner Richard.
Paul, I'm sorry, don't sit down yet. Last question.
Yes, sir.
Are any of these lots sold?
Some of the lots within Bushwood are sold. None of the lots being modified have been sold.
Okay. And so no construction's taken place on any of these lots that are in question here?
That is correct.
Okay, thank you.
Any further comments? If not, I have a motion by Commissioner Kesbon to approve and a second by Commissioner Randolph. Please vote.
Motion carries.
Thank you. Paul, be careful because you may have some gopher problems on this Bushwood. Old business, Lakeshore Villages Phase 1A Act of Correction. Developer owner D.R. Horton. Surveyor is Michael P. Blanchard. Parish Council District Representative, the Honorable Michelle Blanchard. Staff?
Honorable Commissioners, the above caption Act of Corrections been reviewed by the Department of Development and Engineering and no objections offered. Therefore, it's recommended that the Act of Correction be approved.
Thank you, Mr. Chair.
Thank you, Jeff.
Again, Jeff Shane, Jones Fussell, P.O. Box 1810 in Covington, and I represent the owner-developer, D.R. Horton. The request this evening is really to, in my view, subtly change the configuration of some of the lots in the subdivision based on the actual construction of some of the improvements in the right-of-ways. None of these issues create more density. They don't significantly change the area of each lot. I assume that you have a copy of the Acadia Land Surveying plat dated August 17, which depicts really, I guess, 4 different situations where we're asking for some, again, as I will categorize it, subtle changes to the lot configuration. In looking at the proposed act of correction document itself that was tendered to the parish, both staff and I have noted that there are a few minor errors, typos, things of that nature. So if you see fit to approve this act of correction this evening, we ask that it be done pursuant to the Acadia Land Surveying plat dated August 17 of 2018, which is accurate as it relates to the changes that need to be made. If any of you have questions about any of the particular changes as it relates to why did you do this, I'll be glad to go through those.
Thanks,
Thank you.
Is there any opposition to this act of correction? If not, I'll bring it back to the commission. Commissioner Doherty.
Thank you, Mr. Chairman. I will go ahead and put a motion on the floor to approve.
I have a motion to approve by Commissioner Doherty. Commissioner Fitzmaurice.
Second?
I have a second by Commissioner Fitzmaurice. Any other comments? If not, please vote.
Motion carries.
Thank you. Continuing on the old business, Terabella A189, developer owner Terabella Group, Parish Council District Representative Honorable Marty Dean. Staff?
Honorable Commissioners, the above captioned subdivision received final approval at the July 10, 2018 Planning Commission meeting. The approval states that the warranty obligation will be established for a period of 5 years, which is an error. The warranty obligation should be for a period of 1 year since all subphases of Phase 1A were established prior to March 3rd, 2011, the date in which the 5-year warranty obligation began. It's recommended that this change be approved.
Okay. Paul?
Thank you, Mr. Davis. Paul Marone again on behalf of the Terabella Group LLC, just correcting an error, and we would respectfully request your approval.
Okay. I believe there's no opposition in the audience on this. I'll bring it back to the commission. Commissioner Fitzmaurice.
Make a motion to approve?
Motion to approve by Commissioner Fitzmaurice. Commissioner Randolph. Second by Commissioner Randolph. Please vote.
Oops, oh, sorry. Can you guys vote again? I pushed the wrong button.
Can we vote again, please?
Yes, sorry. Yes, please. Motion carries.
Thank you. And the last case under old business is the Grand Maison Act of Correction. Developer owner Alexander Bennett, surveyor is Randall Brown, Parish Council District Representative, the Honorable Riker Toledano. Staff?
Honorable Commissioners, the above captions Act of Correction has been reviewed by the Department of Development and no objections offered. Therefore, it's recommended that the Act of Correction be approved.
Okay. Anybody has any comments out in the, sir?
I'm Alex Bennett. I'm
Okay.
here representing Grand Maison Development, and we agree with the staff comments and just seeking approval on the act of correction.
And what is that correction?
It's just one lot has a side setback line that we made adjustment to that line and missed, the draftsman misdrew it as a rear setback line instead of the side setback line.
Okay. Thank you.
Thank you.
Is there anyone in the audience want to discuss this any further? If not, I'll bring it back to the commission. Commissioner Randolph.
Move to approve the act of correction.
Motion to approve. Commissioner Randolph. Commissioner Fitzmaurice.
Second.
A second by Commissioner Fitzmaurice. Any further discussion? If not, please vote.
Motion carries.
Under new business, I have no new business unless somebody else wants to speak. If not, I'll make a motion to adjourn. Oh, sorry. Commissioner Doherty.
I have some concerns here. Well, the last 6, 8 months, we've had requests from generally Kelly McHugh's firm to exclude green space and so forth from the calculation of fees. And if this is the proper way to calculate fees, then I'm going to ask staff to get with the council and or legal to get with the council and let's change the ordinance. I mean, there's no reason for this stuff to be popping up like this if it's not the right way to do it. Does that make sense? We're granting the waiver, so if that's the right thing to do, then let's put it in the ordinance so we don't have to deal with it and everybody, from the staff to the engineer have to, go through all this every time. The other thing on these active corrections, I don't know, we seem to have had a run of these the last few months, and it's my understanding that there's no fee that's being charged to cover staff's time in going through all these things, and we need to look at charging for the staff's time on these active corrections, especially when it's not a problem of the staff. It was a problem of maybe the engineer or the surveyor or somebody outside the parish government. And I know, things are getting tighter and tighter as far as the budget for the parish and everything, and this could be an easy way to pick up a dollar or two. And if we need a motion to request legal to prepare something, I can do that too. So, but I'll ask legal counsel, what we need to do on that. Jimmy?
I might be able to help.
You want me or Jack?
No, let's let legal take over on this one right now.
If I understand your point concerning the drainage fees, Mr. Doherty, please correct me if I'm incorrect. What you're requesting is for staff and the council to look at towards the codification of any rules concerning a waiver of drainage fees under whatever circumstances it deems appropriate, rather than this commission relying on precedent in order to consider new requests.
Commissioner Doherty.
It seems like, we grant these every time, so why not change the ordinance so that it is appropriate, so that we don't have to, that staff doesn't have to go through all this? Mr. Shane, I think, was going to make a comment, but
well, I would first like to suggest to you, Mr. Doherty, that what has occurred historically has been appropriate or correct, if you will. I mean, the code has already been interpreted up to now to allow for circumstances where a portion of the otherwise payable drainage fees could be waived when the calculation includes acreage that is not going to be touched within the development. Now, I agree with you. I can think of one instance right off the top of my head where it may be a good idea to codify a requirement, for instance, of the developer to put in conservation that area that it requests be excluded from the drainage calculation, so that it cannot be touched. When the developer has sold all his lots, has concluded business in the development, and it falls on the homeowners association to maintain it, there should be some assurances that that area doesn't get impacted in any way as the subdivision is built out.
Okay.
So I can think of that as one example, but up to now, it has already been opined that, allowing for adjustment of the calculation is permitted in certain circumstances under the regs. But I agree with you that perhaps more explicit guidance can be afforded to the commission to review and apply when the requests do come to you moving forward.
Okay. And the other one, of course, was the act of correction coming up with, and staff would, be the ones to come up with, what kind of fees would be appropriate to cover the staff's work on these acts of correction.
Right, I would have to defer to staff to expound on what, if any, fees are already being collected for active corrections, and if it is a request of the commission that those be reviewed, then perhaps that would be an appropriate request to them.
Yeah, I think Mr. Shane has a comment also.
Right, and so we
Mr.
currently
Shea.
don't have any fees for
No-
it, but
no
I
fees?
think it was actually introduced to council this past month to have a fee for active corrections.
I believe it was 200 or 250 or
250.
something.
So that's still being talked over with
It was
the
introduced
council?
at council
Okay.
at the September meeting.
And just for our information, how long does it take you to do an act of correction?
Generally, there's a couple of hours prior to the planning commission meeting. There's planning commission meeting, then subsequent to the planning commission meeting. There's also legal review, and then Ms. Pat has to ultimately sign them, and then we have to get them recorded and document all that. So it's quite a few hours.
Okay, thank you. Jeff?
I'm just going to add that with regard to both issues, the rewrite of the code that's currently going on addresses the drainage fee issue. That's still in draft format, but I mean, that's one of the issues that has been taken up. And the other
Okay,
thing
good. Somebody's ahead of me.
And the other thing I wanted you to know was that last Thursday, the ordinance was introduced by the council that establishes new fees for certain activities and increases fees for many other activities, one of which is act of correction.
Okay. Thank you, Mr. Shane.
Thank you, Jeff. Commissioner Lauren, you have some comments?
Only comment I have is that when you rely on precedent, that's good for people that are here frequently. But if, we quite frequently get attorneys that come in here and make an application, and if they're not familiar with something, they don't know about that. So they don't apply for it. They don't ask for a waiver. Because the rules say, when the rules say you cover the whole property, but precedent says, but you can exclude this if you get a waiver, and they don't know about it. I think that's what Dave's saying. We need to get it a little bit more rigid. Not rigid, but a little bit more fixed.
Well, if I may, Mr. Lauren, the code doesn't describe every specific instance where a waiver may or may not be granted by an applicant. It just has general provisions that say that an applicant may request a waiver of provisions. So it is available to anybody who may be applying to the commission or to the parish for permits. The notion that they can request a waiver when they deem it appropriate to do so, that is available to anybody.
Any more new business? Motion to adjourn.